Hello and welcome to Compliance Briefs on Suspicious Transactions and Activity Reports. In this presentation, we will explore key aspects of identifying and managing suspicious activities and transactions. The topics covered include understanding suspicion, definition and example. Suspicious activity and transactions, what qualifies as suspicious activity or transaction? Regulatory requirements, an overview of statutory obligations related to suspicious activities. Recognizing suspicious transactions, common red flags and indicators. Staff training, best practices for educating employees on identifying and handling suspicious behavior. Internal reporting procedures, establishing effective frameworks for escalation within an organization. Reporting to MOCAs, the process and requirements for submitting a suspicious activity report, SAR, or a suspicious transaction report, STR. Confidentiality considerations, key legal and ethical aspects of handling sensitive information. To begin this presentation, it is essential to first understand the concept of suspicion. Suspicion is a state of mind that is more definite than mere speculation but lacks the certainty of evidence-based knowledge. It can manifest as a genuine sense of apprehension or mistrust, or as a slight opinion formed without sufficient proof. However, suspicion is not merely idle wondering or a vague feeling of unease. Based on the definition provided, an example of suspicion is as follows. While reviewing the client's transaction records, a compliance officer of an audit firm notices that a specific high-risk client has multiple large wire transfers to offshore accounts in jurisdictions known for weak anti-money laundering regulations. The client's economic profile does not justify such transactions, and the due diligence records are either incomplete or lack proper justification for these fund movements. Additionally, there is no clear business rationale for the transactions. Given the unexplained large transfers and lack of proper documentation, the compliance officer develops a reasonable suspicion that the client may be engaged in money laundering and should proceed and file a report to MOCAs. On the other hand, an example of what does not constitute suspicion is as follows. While reviewing the client's transaction records, a compliance officer of an audit firm notices that a specific client is making a few international wire transfers to a legitimate supplier for goods and services. The transactions align with the client's business activities and economic profile. Even though international transfers can sometimes raise concerns, in this case, there is no pattern of unusual behavior, lack of documentation, or high-risk indicators. Therefore, this situation does not justify suspicion. Suspicious activity arises from suspicion relating to general behavior of the person in question, which creates the knowledge or belief that they may be involved in illegal activities out of which revenue might be generated. Suspicious transaction arises from the suspicion created by a specific transaction, which creates the knowledge or belief that the transaction may relate to the legitimization of proceeds from illegal activities. Your statutory obligations include the implementation of robust internal reporting procedures. These procedures should allow all employees to report and disclose any information or concerns that give rise to reasonable suspicion of money laundering or terrorist financing via suspicious transaction reports and suspicious activity reports. A compliance officer must be appointed to handle all internal suspicious transaction reports and suspicious activity reports, and any other related information. The compliance officer will be responsible for assessing and addressing these reports. Once a suspicion report has been submitted, employees must avoid any actions that could be interpreted as tipping off the client, ensuring confidentiality throughout the process. Tipping off occurs when a person discloses any information to either the client or a third person which may cause obstruction or negatively interfere with interrogations and investigations carried out. All internal suspicious transaction reports and suspicious activity reports submitted to the compliance officer must be thoroughly examined, considering all relevant information. The compliance officer will then determine whether the report needs to be escalated to the relevant authority, MOCAs. All evaluations of internal suspicious transaction reports and suspicious activity reports must be carefully documented and retained in accordance with the firm's record-keeping policies. A clause in your engagement letter should be included, informing clients of the firm's potential reporting obligations under the law. This can be done using general wording that also covers other instances where reporting to regulators may be required. Additionally, if a person becomes aware or suspects that another individual is involved in money laundering or terrorist financing, and this knowledge or suspicion arises during the course of their trade, profession, business, or employment, they are legally obligated to report this information to MOCAs as soon as reasonably practicable after it comes to their attention. Suspicious transactions or activities are typically inconsistent with a client's known legitimate business or personal activities or deviate from the usual patterns for that type of client. A thorough understanding of the client's business is essential. This knowledge allows you to identify when an activity, transaction, or series of transactions is unusual or raises suspicion. Red flags are warning signs that a client's transactions or activities may be suspicious or connected to money laundering or terrorist financing. Some common red flags include, though the list is not exhaustive, the size of the transaction, or aggregated transactions, is inconsistent with the client's typical activities as outlined in their economic profile. The client's pattern of transactions has changed significantly. The transaction is unusually complex or lacks a clear economic or commercial rationale. The transaction does not align with the client's usual activities as documented in their economic profile. The transaction involves international parties, yet the client has no clear business reason for conducting transactions with the other country. To effectively recognize suspicious transactions and activities, it is essential to provide your staff with adequate training. Begin by identifying the target audience. Each department or position should receive training tailored to the specific issues relevant to their roles. Once you have defined the audience, the next step is selecting appropriate training topics, such as general AML information, the legal framework, penalties for violations, how to respond to suspicious activity, internal policies, reporting procedures, and practical case studies. Ensure that your staff receives clear guidance on recognizing suspicious transactions. It's important to explain that the situations that may trigger suspicion will vary depending on your client base and the range of services and products your firm offers. A successful training program should be ongoing, not only meeting the legal and regulatory standards for obliged entities but also aligning with internal policies and procedures. This proactive approach reduces the risk of involvement in a money laundering scandal. Training plays a critical role in reinforcing the importance of AML efforts and educating employees on how to respond when they encounter potential money laundering activities. Firms should implement the necessary measures to support the compliance officer's role and facilitate the reporting of suspicious transactions by employees. It is the firm's responsibility to ensure that all employees are fully aware of whom to report to if they have knowledge or suspicion of money laundering or terrorist financing. A clear and efficient reporting channel is in place, ensuring that any knowledge or suspicion of money laundering or terrorist financing is promptly communicated to the compliance officer without delay. Reporting lines should be kept as direct and efficient as possible, allowing staff to report suspicions directly to the compliance officer. This ensures speed, confidentiality, and accessibility. All employees should be made aware that they have a direct line of communication with the compliance officer. All suspicions reported to the compliance officer must be documented. In urgent cases, initial discussions may occur by telephone, followed by written documentation. In some instances, staff members can discuss their concerns with the compliance officer and collaborate on preparing the report. The report should include comprehensive details of the client and a thorough description of the information that triggered the suspicion. The compliance officer should acknowledge receipt of the report and remind the staff of the legal obligation to avoid tipping off. All internal inquiries related to the Suspicious Transaction Report, STR, or Suspicious Activity Report, SAR, along with the reasoning behind whether or not to submit the report to MOCAs, must be clearly documented. This documentation serves as evidence of good practice and due diligence in the event of an investigation, should the suspicions later prove valid. The compliance officer must promptly assess whether to retain the client, in coordination with MOCAs if necessary, and/or reclassify the client as high risk, applying enhanced due diligence measures as appropriate. Records of suspicions raised internally but not reported to MOCAs or law enforcement must be retained for a minimum of 5 years from the date of the transaction. No obliged entity, director, or employee of this entity should share any information with the client or a third party that could obstruct or hinder ongoing investigations or inquiries. This prohibition includes any details regarding suspicious transactions that have been, or will be, reported to MOCAs. However, if a member of ICPAC, in the course of their professional duties, advises a client to avoid illegal activities, this does not constitute a disclosure of information under this section. Violating the tipping-off provisions is a criminal offence, punishable by up to 2 years in prison and/or a fine of €50,000. Furthermore, Article 69A of the AML law provides that disclosure of information in good faith by an obliged entity or by an employee or director of such an obliged entity shall not constitute a breach of any restriction on disclosure of information imposed by contract or by any legislative, regulatory, or administrative provision, and shall not involve the obliged entity or its directors or employees in liability of any kind even in circumstances where they were not precisely aware of the underlying criminal activity and regardless of whether the illegal activity actually occurred. All suspicious transaction reports or suspicious activity reports must be submitted to MOCAs via the GoAML platform. MOCAs has released a guidance on how to register to the GoAML platform as well as how to complete and submit a STR to SAR. It is important to note that for a suspicion report to be useful, all relevant fields need to be completed and as much information as possible should be provided so as to assist in the efficient analysis of the suspicion. ICPAC firms are strongly advised to register on the GoAML platform following MOCA's registration guidelines and to familiarize themselves with the reporting process. By being registered and well-versed in the system, firms will be better equipped to respond quickly and efficiently in the event of a reportable incident, thereby saving valuable time. Additionally, firms should refrain from carrying out transactions which they know or suspect to be related with money laundering or terrorist financing before they inform MOCAs. If it is considered impossible to refrain from carrying out the transaction or is likely to disturb efforts of an operation to track suspects of money laundering or terrorist financing, ICPAC members must inform MOCAs immediately afterwards. The law offers protection to individuals and organizations reporting suspicions of money laundering or terrorist financing from any claims of alleged breaches of confidentiality, including threats or hostile actions. No legal action can be taken against the reporter, even if the suspicions later prove to be ill-founded. However, this protection applies only to the disclosure of suspicions or beliefs regarding funds potentially linked to money laundering or terrorist financing, and the supporting information behind those suspicions. If there is uncertainty, firms should require law enforcement agencies to obtain a court order before sharing any information beyond what was initially reported. In the case of prosecution, the identity of those providing information to MOCAs remains protected to the extent that disclosure rules permit. MOCAs prioritizes safeguarding the confidential relationship between law enforcement agencies and firms, recognizing its importance in maintaining the integrity of the disclosure system. The source of financial disclosures is kept confidential to protect reporting firms and sustain trust in the reporting process. Under Article 27, failing to report suspicions to MOCAs is an offence punishable by up to 2 years of imprisonment, a fine of up to €5,000, or both. Assisting a person involved in a predicate offence, as per Article 4 of the AML law, is a serious crime punishable by up to 14 years of imprisonment, a financial penalty of up to €500,000, or both. Additionally, Article 59(6) of the AML law empowers the supervisory authority to impose strict administrative sanctions, including public statements, license suspensions, fines up to €1 million, and other disciplinary measures. Lastly, tipping off, as per Article 48(3) of the AML law, is a criminal offence carrying a penalty of up to 2 years of imprisonment, a fine of up to €50,000, or both. ICPAC has issued guidance notes on suspicious transactions activities which can be found on ICPAC's website. MOCAS has also released a web users reporting guide for the GoAML platform, which is used to report suspicion on money laundering and terrorist financing. The guidelines to obliged entities are binding and the submitted reports should fully comply with reporting instructions. As of December 13, 2021, reports that do not comply with the guidelines are automatically rejected by the system and are not considered to have been submitted to the unit. Responsibility for taking corrective action and resubmitting the report rests with the responsible entities. The report is considered submitted only once it has been accepted by the system. The guidelines to obliged entities can be found in the GoAML platform at reports.mocas.law.gov.cy/live. We hope you found this useful. For any queries you may contact us at compliance@icpac.org.cy. Thank you and goodbye.